In a city that never sleeps, a lone guitarist makes his leaps. Fingers dance, strings sing a tale of a dream that feels so frail. Echoes fill the silent night. A lost love, a heart so tight. But in this cold, hard world, hope's just a fleeting word. Oh, dreams whisper, oh, dreams sigh. In the darkness they take flight. Heartbreak echoes, lonely cry. In the cold, hard light, guitar soars through the stormy skies. A melody that pierces the eyes. Love's a memory, a distant dream. In this world it seems fingers glide in the fading light. A final note, a last good night. Lost in the shadows, lost in time. Dreams are all we find. Oh, dreams whisper, oh, dreams sigh. In the darkness they take flight. Heartbreak echoes, a lonely cry. In the cold, hard light.
In the shadows where whispers dwell, it's like guitar sings of love's farewell.
I just wanted to know
Echoes of the heart once bold, now lost in the night's cold fold. Secrets hidden deep within, tales of love that couldn't win. Promises made in moonlight's glow, now broken like a shattered show. Sorrow in the guitar's cry, resilience in the sky. Through the night we'll find our way, carrying secrets, holding on today. Memories of laughter and tears, in the silence they appear. Whispers of a time so true, when love was all we knew. Lost in the echoes of the past, wishing for what we had. In the dark we search for light, holding on to what we fight. Through the pain, through the night, we find strength in the fight. Sorrow in the guitar's cry, resilience in the sky. Through the night we'll find our way, carrying secrets,
21.
Start me a card for a parking problem.
Foreigner 23.
Yes, that's where I'm gonna 28 for hot truck when you're ready.
Okay, guys, I just want to get you caught up. There was a fairly quick motions hearing at the end of the trial. And at first I couldn't find anybody covering it, but then NBC 10 was, local NBC. So let me play that for you here. And it was interesting. Speed this up a little.
Please be seated, court is in session.
All right, so we'll have a quick hearing on paper now 682 and 680. First, Commonwealth's motion to enforce compliance with the court's April 16th, 2025 ARCA discovery order. Mr. Brennan, you said you could be brief on both of these, so I'll hear you.
Your Honor, I'll get right to the point. On the motion for compliance, our position is the defense did not comply with your order. This has been an ongoing issue which relates directly to the credibility of potential ARCA witnesses. This is information based on the history and representations made in this case that we're entitled to. I did note before these were produced that we have watched video footage from unaired video from the documentary. We clearly knew that there were text messages and correspondence beyond what was represented to the court. It is not a surprise that I did receive these lists of text messages and calls after I made those comments. However, there is no text message content. There is 99 texts to Mr. Wolf, 6 texts to Mr. Venchler. That does not reconcile with the past positions and representations of the defense to this court, to the Commonwealth. In addition, there are a number of phone calls. And those phone calls, again, I would suggest do not reconcile with the past representations. We have 52 minutes of phone calls on 5 calls with the ARCA main line, 133 minutes, 20 calls with Dr. Wolf, 57 minutes, 23 calls with Dr. Renschler. I find it difficult to accept that these were all for scheduling purposes. We also had your Honor's order, not just for the communications, which are not a complete or a fair production, but there was a order by the court to provide all correspondence, text messages, emails, not just with Attorney Jackson, but with the entire team, including the defendant, Karen Reed, and we have received nothing. This is important because if we look at the first half of ARCA's potential testimony, which is limited to their prior report, we cannot fairly and effectively cross-examine the witnesses until we have the information we're entitled, and that's why I've also asked and suggested that ARCA should be ordered and required to provide that evidence as well so that we can see what is there. It is concerning that there are this many texts, this many phone calls, and the fact that this is totally in contrast to what was represented in the past. So before there's even a thought of ARCA testifying, I think we're entitled to the full discovery that we asked for, the full discovery that the court has ordered. I don't see anything to do with billing or anything else beyond these text message and phone call logs. I want whatever content is available. I think it's relevant material. It's pursuant to your order, and this is woefully incomplete. Should I dive into the second motion?
Yes.
So I can move quickly. The second motion, part of it is moot in some respects. I won't go through the tortured history of discovery. We've gone through it too many times. We don't have time for it. But inevitably, it is clear that we have played by the rules, met our discovery obligations, and as we stand here now, the defense is proposing new opinions, new testing, and they don't even have the parts of that testing yet. This is 2 weeks into trial after we picked a jury. This is at the time of the opening. It is ambush. It is unfair, and we have no ability at this point to reconcile or deal with new opinions and new information. Importantly, the defense's position is they may or may not have a report by May 1st. Our expert will be testifying somewhere at the beginning or middle of May. He is away. He is not available. And so anything we receive at the beginning of May or end of April, we'll have no opportunity to look at, vet, test, reconcile, or even engage in our own testing. This was my concern all the way back in November. I'm not Nostradamus, but this obviously was something that worried me that actually occurred. And so at this point, it would be fundamentally unfair for the defense to get a benefit for failing to comply with discovery orders by waiting until February to seek permission with ARCA. They could have called any expert, asked for any expert they wanted. They didn't. They chose this method, and this is the consequence of it. And at some point, the defense has to bear the burden of their decisions. We will not have the ability to rush through, have Dr. Rentschler come in days before his testimony, try to reconcile, be inadequate. I've had a brief correspondence with him. It's simply impossible. That's why we suggested, although we certainly didn't want to move the trial date, that was the only remedy if the court was going to allow any new opinions, evidence. I say to the court that they should not be allowed to offer absolutely anything new, not only because they missed the discovery deadline. That's technical, but the reality is we're all trial lawyers. We've all tried a lot of cases. It would be a disadvantage, fundamentally unfair, and because of their own choosing. And so anything new, we will not be able to reconcile. We would not be able to proceed with our expert in a fair manner. Thank you.
Okay. Mr. Alessi, is this you? I'm going to ask you to be as brief as you can be, please.
Your Honor, I understand your request to be as brief as possible, but this is the first opportunity the defense has had to respond to almost every allegation that's been made. We haven't had an opportunity. So I certainly respect the court and what the court's request is, but it is going to take a bit of time to put facts out. And I want to separate two categories that the Commonwealth has conflated. The Commonwealth has conflated the issue of what text messages exist, which text messages don't exist, what's been turned over pursuant to orders. And I would like that to be clear to the court factually, because the Commonwealth has misstated just now 3 times the facts.
So I asked this morning, there were 100 or so texts referenced in the exhibit, whatever was presented by you folks. I asked if Mr. Jackson, if he provided them, because my order was clear they were to be provided, and he said no. And I asked you at sidebar whether they were deleted, and you said yes, in due course. I have no idea what that means, Mr. Alessi. Why don't you explain that?
Well, thank you for the opportunity to explain.
So the bottom line here is that the defense had text messages between their lawyers and ARCA. Now, these would have been about a year old, not much more than that. The oldest they could have been would have been March of 2024. That sounds like hundreds of texts, certainly many, many dozens. And the defense deleted them. It's just unbelievable. And they're going to try to argue here that there was no preservation order saying that they need to keep those texts. But you're deleting texts? These guys know better than that. Give me a break. There's no innocent explanation for deleting those texts.
And here's what it needs. Like anybody's phone, those text messages are 2 years old. They don't exist.
So can
I don't know why he says 2 years old, because ARCA could not have communicated with the defense until March of last year. So I know he's saying, I think that was Aurora that said that. I know he's saying 2 years, but the defense did not know about ARCA. This is what they've claimed until the federal report came out, which they did. Neither side got that until March. So there is no way that. So it's not 2 years. It's 13 months at the most. At the most, it's 13 months. So again, it's walking up right to the edge of line. It's more than a year. It's less than 2 years, but it's really basically a year. So, and so these messages would have been from last March, maybe last April. So I don't know why Alessi's going to get away with saying 2 years. It's been a year.
You also tell me, aren't the ABA guidelines the council is supposed to keep everything in a case for 5 or 7 years?
I do not believe that is the ABA rule with regard to experts. I'm unaware
In
of
regard
that.
to your client, and this was in regard to your client's case, right?
I'm sorry, Your Honor, I didn't hear you.
Records kept regard to your client's case, which these are experts that were, I mean, there's 100 text messages
100.
leading up to trial when I was told that by you that there was a pause email, and then all of a sudden out of the blue a bill appeared in July. This shows that's not true, Mr. Alessi.
Your Honor, that was a different question that Your Honor asked me back then. That was about emails. That was not about text messages.
Have emails been provided?
Yes, Your Honor.
Okay.
All emails have been provided. And that is why we are in compliance with all orders. And I will say also with regard to text messages, we have provided, pursuant to every order, every single text message that exists. Mr. Brennan just said, I believe there has to be more there. There's not more there, and I don't believe there can be an order of preclusion based upon the speculation of opposing counsel that there must.
Again, there's not more there because they have been deleted. They've been destroyed by the defense.
Be more. We affirmatively created a document, Your Honor, to be more transparent than the records, where we summarize all of the communications. Yes, we don't have the text of the text messages, but we were completely forthright and set forth every text that was made. Plus,
So we deleted the texts so you can't read them. But otherwise, we were honest. Unbelievable.
we turned over from Ms. Little, the only other person on the defense team who communicated with ARCA, we turned over her texts and the texts of her text messages. There is nothing else in existence to provide.
So they turned over Miss Little's texts, but they deleted the texts between Alan Jackson and Dr. Wolf. I mean, it's just ridiculous. It's so the texts that did damage to them, those are obviously the ones that they deleted. Unbelievable.
And importantly, the defense was under no order to preserve the text of text messages. And we have never received, as part of discovery in this case from the Commonwealth, any communications between the Commonwealth and its several experts. That has not been what has occurred in this case. But of course, once Your Honor on Friday issued that order to provide everything, we provided everything we can that we had. The bottom line is, Your Honor, we've turned over absolutely everything we have. And in addition to that, we created a document so that it would be easier. We're the one.
I mean, imagine if the prosecution had deleted all of the Sallyport videos, and then the defense came and said, you have more videos and we want them. And the prosecution said, well, we would give them to you, but it's too late. We've already deleted them and you're just ordering this now.
Who showed all of these text messages from Mr. Jackson historically. We created that document. There's no basis for a discovery violation. There's no basis for an order violation. We are in full compliance. So that's the prong one, Your Honor. Prong one is what Mr. Brennan has alleged is incorrect because we turned over, and we did it recently and consistently. We've turned over all emails and Ms. Little's text we provided. There are no text messages in 2024, and there's no order that required those to be preserved, and there is no discovery violation because we can't be in violation of not turning over something that doesn't exist.
All right, go to the second.
Thank you, Your
motion-
Honor.
Motion.
The second part of the motion, Your Honor, is the most maddening for the defense. And this is the timeline that I can go through very, very quickly. And essentially, what the Commonwealth just argued is we will be so prejudiced that if we get the work that ARCA is underway, working on, that we will be prejudiced because we won't have enough time to address it. Your Honor, the facts show that the timeline for this has been caused by the Commonwealth, not the defense. And I can do it quickly. July 2024, the first trial concludes. November 2024, 4 months later, the Commonwealth decides to retain Aperture. Their decision to wait 4 months to retain an expert, we're the defense. We defend what the Commonwealth alleges. January 30th, 2025, 2 months after that, and 6 months after the first trial, we get an Aperture letter report that's barely discernible about what they've done. It's a 1 page and 1/4 of conclusions and opinions in outline form. Next, January 31, 2025, we get the initial Aperture 140 slide presentation. January 31st, February 5th, we get the case file. In February of 2000, or February 19th, we finally get the raw images from Aperture in the scans. That's the first time we get raw images and scans. You can't have an expert work on anything until you even get those raw images in scans. We move, and we have a hearing on March 20, 2025 to preclude Dr. Welcher because the slides are so incoherent and the report is so insubstantial. We can't tell what it is their theory is. So then on March 24th, and at that hearing, the Commonwealth agrees to redact and revise that. So we're already into March 20th. The Commonwealth agrees to redact and revise. Your Honor put the defense on a short leash. We accepted it. And by March 24, we received the PowerPoint that was of the Aperture that was supposed to have two things happen. It was supposed to be redacted, and there were certain things that were supposed to be changed. What did we get on March 24th? It wasn't redacted, and there were 3 substantive changes to it. The Commonwealth has said twice, including today, there were no substantive changes. There's 3 of them, and to the extent Your Honor wants to hear, I can detail exactly what those changes
So
were.
why don't you highlight them very quickly, because
I
need
will,
to
Your
say
Honor.
something.
I can do it quickly. Thank you for the opportunity. First one, slide 36, they changed the image of 34 Fairview. No small change. 102, they changed the conclusion regarding the time that the tail light was broken. No small change. 123, they changed the image of 34 Fairview. No small change. So we ended up getting those changes, and I want to be clear on the date. That's March 24th. We have a hearing on March 25th. We agreed to provide our response to these revised Aperture documents. Here is the key data point. On March 26th, the defense engages ARCA. Just 2 days after we get the revised PowerPoint with 3 substantive changes. And then we started to respond and provide more information. On March 27th, we responded to the Commonwealth's revised PowerPoint and the Welch report. And then the last 2 items, we renewed our request to preclude Dr. Welcher on Delbert Lanigan grounds. April 1st, and this is another key date, the court decision allowed Dr. Welcher to testify, but also allowed the defense to re-raise objections at trial when Dr. Welcher testified. What does that timeline show? That timeline shows that the Commonwealth took 6 months from the last trial, 6 months, and the defense took merely 2 days after they got the final report of aperture to retain ARCA. Last point I want to make, Your Honor, is the argument of the Commonwealth that we strategically waited to retain ARCA. Nothing could be further from the truth. As the court knows, and has been the case with this unorthodox situation, ARCA was retained by the U.S. government. They worked pursuant to the U.S. government, and we had to get the permission of the U.S. government to retain ARCA. We moved expeditiously to do that. We got the permission from the government, and as soon as we got the permission from the government, and as soon as we got the final version of aperture documents, including scans, we put ARCA on it. It has only been since March 24th, not even a month, have we had finally the information from aperture, which is still inadequate. Our experts still say, with regard to what aperture did, in some instances, they can't even figure it out because the information is so inadequate. Nonetheless, because of all the considerations we're aware of, we had ARCA proceed forthwith with post haste. And they are working post haste. But, Your Honor, we are the defense. That's where I started. We had to understand as best we could what aperture did. In conclusion, 2 points. No violation whatsoever on text messages, emails, court orders. All complete, robust compliance. And with regard to the allegation that there was something said, that there's some surprise that there were so many text messages, on June 10th, 2024, and I've got the transcript albeit on an electronic device, right in front of me. I just got to get the passcode. Mr. Jackson read a text message right live that he had with ARCA. He read it, and here's what it said. The court, okay. Mr. Lally, so her issue is that she is available this week, but not next week. So I really need to get her in on Friday. Mr. Jackson.
Hold on. The court reporter can't hear you. She asked you to stop.
Oh, I'm sorry. My apologies. Am I going too fast? Yes. Thank you. All righty. Go ahead. Thank you. My apologies. So, Mr. Lally, so her issue is that she is available this week, but not next week. So I really need to get her in on Friday. Mr. Jackson. Dr. Wolf just texted me and said, I presumed you were in court. Give me a call when you're available. The court reporter, I'm getting an interference. Mr. Jackson, I'm so sorry. The court reporter, that's okay. We have been completely transparent that there were text messages as opposed to emails, text messages about scheduling, about other administrative matters. Mr. Brennan is completely free on cross-examination of ARCA to address every one of his speculations, every one of his suspicions, every one of the ghosts that have been created on this topic. He can address them. If he thinks that we're wrong, we're misstating, he's got the opportunity to speak to ARCA and ask those questions. Your Honor, it is improvident to, based upon speculation, preclude the defense from putting in a defense.
I'm not making a conclusion today regarding precluding the defense.
Okay, all right.
All right, so I need you to wrap it up because there's something I want to say.
Certainly, Your Honor, I'm going to wrap it up in 10 seconds. There are no violations of any discovery order, no violations of this court's order. And with regard to the retaining of ARCA, because we're the defense, we acted expeditiously in response to the information we're getting. And this can be tested with ARCA, this statement I'm going to make. To this date, ARCA still has trouble understanding what it is that Aperture did and didn't do, which was the reason for my Dalbert Lanigan motion, but we proceeded nonetheless. Happy to entertain responses to any questions.
All right. No, thank you. All right. So as you all know, I previously wanted to have a seat, Mr. Alessi.
Thank you, Your Honor.
I previously found and believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears
To be deliberate then?
to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations.
So it's another violation, and it seems to be deliberate.
We need to figure all of this out before you're allowed to call these witnesses. So I'm going to have a voir dire hearing this Friday. I know we planned on having you. I need the ARCA witnesses here Friday morning. So we need a voir dire, if you intend to call them, a voir dire on all of this. And I will be sending an order for production of records. I just need to amend it for ARCA to bring all these items with them. So Friday will be for ARCA for a voir dire hearing in the morning. So we'll see you tomorrow for trial, Friday morning for this.
May I inquire briefly for scheduling purposes?
Yes.
In light of the hearing on Friday, will it still be half a day, or are we expected to call witnesses on Friday?
No, it will be, if we could do, Mr. Alessi, how long do you think this voir dire might take?
I don't have an answer for you, Your Honor, right now, because I got to talk to ARCA and I've got to understand what they have and what they don't have. So I think, in fairness, I think it could take some time.
All right. So no witnesses for Friday, and I think we'll give the jury the day.
And will it be a full day on Thursday?
Yes.
Thank you very much.
Yes. All right. So we'll see you then. I will issue an order, hopefully before the close of business today. Jimmy, can you stay and get this out today?
Sure.
Okay. All right. Thank you.
All right. I'm not going to stay on long, but this is why you don't mess around with these people. This guy, Mike Boyer or Bayer, Boylever or whatever he is. I don't know. These people are just pieces of shit. I have no idea who this guy is. Never saw him before today. Wants to make a name for himself. Does he have his own YouTube channel? Does he do anything? Is he a journalist? Probably none of those things. So he challenges me to a debate on day one of the trial. The trial has already started. The time for debating is past. We're going to be covering this trial every day of the week. And I politely say, no, I just, I don't have, let's let the trial take care of this now. I don't have time. I don't know who you are. Why do I want to give you any more attention than some other idiot who just pops up on the screen? But I said it politely, and he says, I want to give you a fair shake on camera. On camera. What does that mean? You're saying no problem. What I know through my experience with you, you have experience with me? Who are you? So if you have experience with me, I've never spoken to somebody named Mike Boyer. So is this a fake name now? Is this a pseudonym? Are you somebody else who has presented yourself or communicated with me on some other level, and now you're in here with this fake name, Mike Boyer? I don't know, because you say through my experience with you. Now, so you get these people like the Broken Baker, who English is their third language, and they aren't careful with their words. So when you say your experience with me, I've never met a Mike Boyer. I've never spoken to a Mike Boyer. Did you misspeak when you said your experience with me? Is English also your third language? He says, you are about making money from this case, not true justice. So this is the point where I have no choice but to ban this guy because it's stupid. He what basis do you say that I'm trying to make money on this case? I mean, I've addressed this so many times with people. If I wanted to make money for this case, I would have been like you, an idiot who stayed on the conspiracy, because that's clearly where the public is. That's where 80% of the public is. You make a lot more money by going with the conspiracy. I lost. So I'll tell you just a little bit about the history of this channel. So by the summer of 2023, I still had not done a live show. I was doing shows that I would script ahead of time, record them, and then video edit them. It was a lot of work. I never even considered the possibility of getting donations on lives. It was just an alien concept to me. All I ever hoped for in terms of money on this was that if you can get to a point where you get 20,000 views on something that you create, you make enough dollars to maybe support the channel enough. 20,000 views wouldn't really do it, but you probably need to get a couple 100,000 views to get enough from AdSense to support the channel. And that's all I ever wanted to do, was just to break even. I started the channel not to make money. I started the channel as a way to try to get my stories out there. Reality is I've never come close to getting those kind of views. But then when I started doing lives, you do start getting donated. That was, so I did my first live, I think it was probably July, early July, possibly late June of 2023. And not long after that, I added a partner, Dave McGrath, and then I added another partner, Aaron Warschauer, by, say, early August. And the first month that any income came in from this channel from donations was July and August, I guess. July, I hadn't monetized it yet as of July. I had monetized it. I hadn't set it up. I hadn't linked it to a bank account yet. So there was no way for even those donations in July and in August. I had no way of even getting them. I never even thought about it, And so, but I did get several $100s in donations that came in between in July and August. And then finally I linked it to my bank account in September, and like $460 came in. But here's the thing. When I flipped, all of those donations dried up to zero, because most of my audience and all of those people making those donations were FKR. I gave up the only money that the channel was taking in order to pursue the truth. That's the difference between me, and I don't know who you are, but presumably you, and certainly the sources that you follow. So for you to come in here and baselessly accuse me of trying to make money when you don't know anything, and I guarantee it would have been no debate. Look, I've gone through this with Lauren De Laguna. I've gone through this with Broken Baker. I go through it with Nick every night on TV. It's not a close debate. It's not because I'm the smartest guy in the world. It's because I have the evidence and the logic on my side. The prosecution has the evidence and the logic on its side. The evidence is irrefutable, and you just have to be smart enough to follow it. It's not complicated evidence either. So, you're obviously not very smart, Mike. You think you're a big hero, and you want to come in here and challenge me to a debate and be rude. Well, now you're gone. So you can go back to that little glare world that you emerged from and try to suddenly make a name from yourself. And that's just the way it is. Just like I said. So, and when I flipped like that, not only did all the donations stop coming in, I went September, October, November, December, zero money came in. Or if it was a couple of dollars here and there, it wasn't enough. That YouTube has to have, I forget what it is. I think you have to hit a certain amount before YouTube will even cut you a check. So nobody sent me any money. So I did not, this channel did not make any money after I flipped for 4 or 5 months. Then in January, it slowly started to add a little bit of donations. It was maybe $200. or something like that. And by the time of the trial, it was up to like $900, $1,000. And then it went back down to like a couple $100 after the trial. So there's not some huge amount of money here. My membership thing is set very low. It's not like, and I probably have like 125 members. Turtle Boy has tens of thousands of members and he's charging $14.99. So he's making a ton of money. I don't make any money off that. Or make I don't say it's a small enough money that, trust me, you would say, wow, why is this guy putting all this time for it? Because I'm not putting in the time for money. The book, I've never seen, I don't expect to ever see any money from the book. They're not, the publisher won't pay me until it's 6 months after it's been out. And they have to recover all their expenses first. So I don't see any money coming from that either. The documentary didn't pay me anything. So I'm sorry, dude. You're going to have to go make your name. You're going to have to go earn your name just like everybody else. You can't take a shortcut. Go start your own channel. Start doing research. Start developing sources. Develop a style. Win some followers. And there you go. Don't try to skip the whole process by just thinking you're smart, which no doubt you're not. And then you're going to jump in and just think you're going to jump the whole process by taking me on in a debate. You're not the first one. Look at that. Nan Gallagher is trying to do the same thing. But they all do it in their cowardly way. They don't actually send me a message saying they want to debate me. Nan Gallagher could send me a message on Twitter. She could send me a message on Facebook, or she could send me an email. She never has. She doesn't want to debate me. And at this point, I won't have time to debate her now anyways. If she had challenged me a couple of weeks ago, I would have done it. But now the trial has started, and the trial is going to eat up all of our time, Monday through Friday. In addition, I have some pretty aggressive medical treatments over the next month. I don't have time to come in on a Saturday and debate some Yahoo, and it's going to be someone like Broken Baker who just asks stupid questions and interrupts you 3 seconds into the question every time. So anyways, I didn't want to do a long show here. I just wanted to get you guys caught up on this motions stuff. And so we are going to have a voir dire on Friday. Now, we were already going to have a voir dire, but it was going to be shortly before the ARCA guys testified. And they weren't going to testify until during the defense part of the case. But the reason the judge is pushing this up to where they're going to testify this Friday is because ARCA is performing new testing, to rebut the accident reconstructionists employed by the prosecution, a company called Aperture. And the prosecution is saying, look, if you're going to do tests, it's too late to do those tests. We need to have the trial's already started. We need to get that stuff now so we can get that to our experts and let them analyze it. So today, actually, what the judge did here is not necessarily good news for the prosecution. Because what the judge did here signifies that she may let this new testing done by ARCA come into play. That's why she has scheduled this to be Friday. If she was of a mind to not let any new testing, like Hank Brennan said, no new testing should be allowed to be reported after the trial has started. Well, if the judge was going to go along with that, then she would not have rushed up the voir dire. She would have had the voir dire when it was originally going to be scheduled, which was during the defense part of the trial. But the fact that she's doing a voir dire this Friday means there's a pretty good chance that whatever this new testing is that's done by the ARCA guys, it's probably going to be admitted. They're probably going to be allowed to present it. But we'll see, because as the judge said, once again, the defense has deliberately not complied with the rules. And I would say even worse. I mean, they've deleted those messages. And there's no innocent explanation for those. And unlike the Jen McCabe deletions, these are real deletions, because none of Jen McCabe's messages are gone. None of them ever were gone. None of them. So the only thing that's been deleted here are the defense messages between ARCA, which has been shady. Why would the defense have 100 messages with ARCA? And listen, the defense has said the only thing that, so David Yannetti said last year, I forget if this was right before the trial or during the voir dire, but David Yannetti said the only thing we're allowed to talk to ARC about is scheduling, is travel arrangements. You took 100 messages to talk about travel arrangements. You had to delete those messages. I call bullshit. There's definitely was more that was discussed in them. Are we ever going to know? My guess is no, because these ARCA guys are just as shady as the defense. We saw Dr. Wolf trying to prepare Alan Jackson, help prepare for the questions the prosecution might ask last time. So no doubt, if ARCA hasn't deleted their messages, they're deleting them right now, but they probably already deleted them. And what can you do? They're going to show up in the court and they're going to say, yeah, we already deleted those messages. What can be done? Not sure what can be done to remedy that. If they testified that it was deleted, then it was deleted. What are they going to do? They're going to turn in their phones? So I don't know. So Jones says they should not be allowed to testify. While I agree with you, I don't think that's going to happen. You know, they're not going to take away the only accident reconstruction experts that the defense hired. It's such a momentous decision that I don't see them doing that. But clearly the defense has been shady here through this whole process. And what were within those 100 messages that clearly, if that was not all about travel arrangements, so what were in those messages that have been deleted? So, you know, it's a problem. Latin King teacher was in Worcester where TB lived, approximately 2019. I don't know who Latin King teacher is. Rachel Rollins took down Latin King pin Sean. Oh, I don't know what you're talking about. That's like code to me. I don't Latin King pin Sean something Rev. I have no idea what that means. So you're gonna have to email me as to what you're talking about. I know you probably couldn't fit it all into the chat box. But I don't know what any of those things are. Foghorn Patty says she saw a clip of Vinny saying the prosecution didn't mention Proctor, and Sue O'Connell spinning the video of Karen. This is what we're up against here. So we had on Channel 7 news in this house, and they started out by saying the Karen Reed trial began today, but all anybody can talk about is what the defense said. And then they spent several minutes showing Alan Jackson's statements this is on Channel 7, local Boston Channel 7. And then after minutes of that, they finally went into a little bit of what Hank Brennan said in the prosecution. So it was a completely biased report. It was like something political around here, which is always going to be one-sided. Why is Channel 7? Why are so many of these channels biased in favor of Karen Reed? Numbers, 75, 80% of the public thinks it's a conspiracy. And none of these channels, and I'm sorry if this is going to sound a little partisan, I'm a moderate, but all of these channels tend to be very politically liberal, which means for a very, very long time, they've been used to fudging the truth. They're not committed to the truth. They're used to framing every debate in a way that helps their side. And so this is the same thing. And like I said, I'm a moderate, I'm neutral, but all my life I've been watching the way Boston channels and certain other channels like CNN frame the news. And I hate that. I don't like to watch Fox either because that's one-sided. I wish there was a neutral channel that doesn't seem to exist anymore. But certainly in the Boston area, 4, 5, and 7, they tend to be overwhelmingly liberal and they frame the news. They're just used to doing that. So it's second nature to them, and they have no problem trying to frame this debate in the same way. And in this case, it's not for political reasons or ideological reasons. It's because numbers. Karen Reed has got 75% of the public, and that's all because of what they manufactured. The defense team was able to manufacture. So is this now the future? This is why this case, the stakes are so much higher. Obviously, justice for John, justice for Karen, justice for the witnesses falsely accused. Those are huge factors here. But The other factor is just justice itself, whether the justice system can work. When you now have a situation where if defense teams have enough resources and they have the right kind of case, they can find their own turtle boys, stir up social media. And if they manage to get public opinion to turn beyond a certain point, then the regular media is also going to buy into those numbers, and court TV too. And it's unfortunate. Because the defense can try their case in public. The prosecution cannot do that, or is much more restricted. So it's if not, we're reaching a point where now every big trial is going to be done through social media, which is ridiculous. So now this guy Mike Boyer is popping up as Mark Boyer. So we have no idea who he is. He doesn't tell the truth about who he is. For all we know, it's the Glarer. We have no idea who he is. What we do know is that he's not honest. That's clear. He's coming in under different names all the time. So he's a dishonest little creep. He's on the right side. If you're dishonest, go stick with Free Karen Reed. That's where you belong. No question about it. All right, guys. I want to take a shower and get ready for Court TV. I have to be on there at 8. And don't forget, Kate is doing a live show at 8 and with some kind of a panel on there where people are welcome to join her and contribute. So I know. Again, thanks. We won't normally do this kind of show after a day of trial, but we had the motions hearing, so I wanted to get everybody caught up on that. So thank you, guys. Talk to you soon.